Hello, everybody out there in workers' compensation land. It's Mike Sullivan here, coming at you again with another webinar on COVID. I'm here with Lisa. Hello, Lisa.
Hello, Mike.
Hello. We will introduce ourselves. I think we got our pictures on the next one. This is on AB 685, by the way. But that's me with all my hair. I could comment on every single time because I'm always shocked that I have hair when I see it.
And that's me, and my teeth are not nearly that white.
Yeah, mine aren't either. I'm pretty sure, I'm convinced that they photoshopped us.
Absolutely.
Yeah, looks good though. We should take a trip down to the cosmetologist and whiten up. Yeah. So there's a contact information. If you want to talk to us, then you have it. You know, I want to mention, I'm the general managing partner of the law firm, and Lisa is a member of our employment law section here at the firm.
That's
so
correct.
She knows all about the employment law stuff, and I know all about the workers' comp stuff. And it's good because we need both for this presentation. I have a slide here telling you about who we are and making the distinction between us and Sullivan on Comp. This webinar is a production of Sullivan on Comp, which is a legal treatise. If you're listening to it, almost certainly you know what Sullivan on Comp is, and you're probably a subscriber. We have close, I think the last count was almost 7,000 subscribers for Sullivan on Comp. I believe it has become the standard text in workers' compensation law. For everyone that practices workers' comp in California, claims adjusters, lawyers, everybody. And of course, I'm also the principal of Michael Sullivan and Associates, the law firm. But today I'm wearing the Sullivan on Comp hat, which means I'm neutral. And we're just going to try and go through all the issues the best we can and figure it out. I'm not acting like a defense attorney in this instance.
Can I act like a defense attorney in this instance? Thank you.
You may act like a defense attorney. But I have to be above the fray, Lisa. So anyway, those are our respective roles here today. Those are the Sullivan on Comp presentation, and normally they're only available to Sullivan on Comp subscribers. We're actually letting the whole world see this web series, including non-Sullivan on Comp subscribers. We're sending it to everybody, and anyone can go to the site and look at it. I want to talk more about the web series in a minute, but I wanted to point out also that we do have a book. Lisa, you wrote a lot of this book.
I did, yes.
On the employment law section. But it's up to like 300 pages now if you printed it out. It's just getting longer and longer because we update it constantly. But it's a book on COVID-19. It's designed to answer every question, employment law, workers' comp law, that you may have, explore every concept that we can get our hands on. And we think it's really super. And we had at one point 1,500 people a week looking at it using this book. It's free. It's on our website. You can get it. I recommend you get it, bookmark it, use it.
Yep.
It's got all of our thought process in here, and every question that's been asked to us, we've integrated into it. It's cool. It really tries to answer everything. And there's, of course, our now 18 parts, our 18th part of our COVID series. And we did all kinds of stuff way back in the beginning of the pandemic. Yeah, me and Eric, you worked with Eric, did stuff on employment law practices. We got into the workers' comp, the issues. When do you provide a claim form? When don't you? When is it work related? You know, when is it? How does it interact with comorbidities? Then we got into the presumptions, the executive order, psych injuries, return to work. I did an interview with Jake Jacobsmeyer, who is in a coma for a month with it. Everyone knows who Jake is. He's a great guy. It was a really interesting interview, but issues in workers' comp, frequently asked questions. And then comes the, we did one with the doctor on the developing medical landscape, so that was cool. And then most recently, we did two on 1159. And we're not talking about 1159 today, really, but that was the presumption statute that said that there's 3 different presumptions that employers will face when it comes to claims of workers' compensation injuries that have to do with COVID. So, you know, we went in depth on that one. Man, there's a lot of people listen to that one. It's really confusing, long law. Like I said, 3 different presumptions, all different categories, compare and contrast. We did a sheet that compares and contrasts the different presumptions, and it's out there in the world. We sent it to everybody. And I think most recently we released frequently asked questions on it. So, you know, we're spending all the time at the law firm talking to all of our clients, you know, the outbreak presumption with the information that has to be provided to the TPA by every employer in every building, every day, every positive test. It's crazy. Yeah. It's crazy.
And what we've noticed is not only are there new laws being drafted and new regulations, we're finding that our advice to clients that we gave in the beginning of the pandemic is now different as a result of different laws, governmental agencies' input. So, you know, this is a rapidly changing area of the law.
Yeah, our FAQs, we updated them over the weekend.
Yeah.
Yep. So, well, anyway, we did another one last week, and I think just a couple of days ago. It came out again on an encore presentation on issues and implementation. And it's just a lot of stuff. It's a lot of stuff. And like I said, we as a law firm, we got almost 90 lawyers here now, and all of us are just talking to clients all the time about how to implement. So anyway, that's the webinars. The last administrative thing I wanted to talk about was our handouts. If you look in the upper left-hand corner, you can find the part where you can get handouts, and there's actually two. Okay, so there's one which is a sample letter that employers can write to their employees, the notice that they would give that's required by the statute. The second one is, we figured out, we're going to talk about it, there's like all these different people that employers have to report to or give notices to: OSHA, employees, heads of subcontractors. It's a bunch of them. So we made a chart. That chart should be really helpful to employers to determine like when they have to give notice or when they have to report to whom under what conditions. So you can print it out, take a look at it, follow along. We hope you find it useful. Again, we're sending it to everyone in the world, so it's probably already hit your inbox in one way or another. But that's where you get your handouts. So here's what we're talking about today: is Senate Bill AB 685. This is not 1159. This is not the presumption statute. It's a whole different statute. And the level of consciousness about the statute, I don't think is really very high right
It's
now.
not.
Yeah.
No, it's not. I think most employers are just trying to return employees to work, get the work done, and deal with, furloughs and layoffs that they made early on.
Yeah.
I don't think the notice requirement is on their radar yet.
Yeah, I think the TPAs all know about the presumptions, and they're going to their employers and saying, hey, you have to do this, right? But AB 685, well, no, not really. And it's still a really important statute because it sets out a bunch of notice requirements and reporting requirements for all employers in the state of California. You have to do it or they come and hurt you. And people don't even know about it.
They may not physically hurt you, but they will fine you.
They will fine
substantially.
You. Yeah. What do they do to you?
So you can get a fine up to $25,000 per violation from Cal OSHA. So it's significant. You really need to follow these notice requirements. I mean, and in addition, of course, you can have employees sue you for failing to maintain a safe workplace.
Yeah, that's true too.
Yeah.
The negligence. Yeah. So anyway, we're here to tell you about it. It doesn't take effect until January 1st, but it's good to get these things in place and get you figure it all out now. Believe me, it's not easy to figure out. It's not an easily constructed statute. Me and Lisa spent a lot of time over last week just trying to understand what the hell this thing said. But I think we have figured out what the hell this thing said. At least to the extent possible. Anyway, so what we're going to cover is first the new notice and reporting requirements. And I'll tell you what those are in a second. But fundamentally, you have to tell employees when you're aware of someone around them having COVID, and you have to report to the local county health and to OSHA. So we need to go through what those requirements are and how they work. I'll compare it to the other requirements that are the obligation of the employer, like in particular, the SB 1159, a lot of the terminology is the same. The standards for when you have to report or when there's a notice due uses a lot of the same terminology. Doesn't always mean exactly the same thing. So we'll compare it and let you know like when you have one and when you have the other. Same thing with OSHA and the workers' comp requirements. And then we're going to talk about how this might actually work in the real world, how we're going to apply it practically. So that's our agenda for today. I'm very excited.
Oh, me too.
Yeah. I was thinking, we were talking about it before. Mike Bell was saying, notice and reporting requirements does not sound like a really riveting webinar.
But you have no idea.
Right. And then why do you care if you're a claims person?
Right.
Because your employers care, I guess.
Yes, they do.
Yeah. Yeah. So you better know what your clients are supposed to do.
At least spot the issue.
Yeah. We got to know this stuff. There's no way around it.
Yeah.
So let's get to work. All right. So fundamentally, the AB 685 provides for three things. First, there's a notice to employees and others at work. So let's say that someone, and we're going to talk about it, exactly what that means, but if someone at work has COVID and you're aware of it as an employer, you have to tell the employees and you have to provide a notice, which is a letter, which is really long, to employees and some others. So this is like a new requirement. Now, look, we're already doing that, right? Most California employers, are they telling is there any law right now that says you have to tell your people if someone else has COVID?
There's not. There's not, but there has been general guidance that we've been giving employers, and it's interesting. Employers are sometimes reluctant to tell their employees because we have kind of two types of employees who are scared to death of COVID. and don't want to be around the workplace unless everything is perfectly disinfected. And then there are others who don't even want to report COVID symptoms because they're afraid they're going to have to isolate and be off work. So, so we have competing interests here. But now what we have with AB 685 is you have to notify your employees when someone is positive in the workplace.
Oh, okay.
Yeah.
Yeah.
And
so
we'll talk about
could you
that.
get sued if you don't notify the, I mean, there's no legal requirement that you notify, but it's just prudent to do so.
So I think that you can, and you would get sued for failing to maintain a healthy and safe work environment.
Okay. So, I mean, look, this is good. I mean, we should be doing this stuff now then.
Yes. Yeah. Yes.
The employers probably already are doing it for the most part. And then there's another requirement. This is the second thing that this bill does, is create reporting requirements to the local health authorities. That means you got to go to the local county health organization and you have to tell them about when you have COVID problems. And that's another requirement that didn't previously exist, but now it does. And finally, there's expanded enforcement authority by OSHA, meaning that OSHA can come in and shut you down even more aggressively than they used to. And so that's important to know for employers, like when OSHA can come and get you and under what circumstances they can. So that's the three things that AB 685 does. I think the most important is the notice requirement. So we'll spend most of our time on that. But at the end, I'm going to compare all the different notice and reporting requirements that employers have in California in regards to COVID right now. And we'll go through and I'll show them. There's 4 of them really. And I'll show them to you, show you the chart, and then I'll compare and contrast so the employers can just go by the chart and decide what they have to do under what circumstances. So that's what we're doing. It's important to note that this takes effect January 1st, 2021.
Yes.
So,
but start planning now.
Start doing it now.
Yep.
Yeah. Just pretend like it's now. I think.
Yep.
Yeah. And then, like 1159, it's repealed as of January 1st, 2023. I always thought that was really interesting. I mentioned in the last webinar. I mean, when you repeal a statute, it goes away.
Yes.
Like goes away unless there's a final order and time for appeal is exhausted, it goes away. So if you have a presumption under 1159 and they repeal that and you're in the Court of Appeals, this legal standard for the entire case changes. It has to be remanded.
Yes.
Yeah.
Yep.
So they'll probably extend it, but anyway, it's important to keep that in mind.
Yep. So
the next slide is what we want to mention, like what they actually stated their purposes, the legislative digest or whatever you call it. They say, you know, this is the purpose of this, and it's to better track and trace workplace exposure and positive COVID testing are the first two. They want to track it. They want to trace it. I guess the local counties,
right?
You know,
where are the cases coming from? What industries?
Right.
Right.
So
are there clusters?
Action. Yeah. Yeah. So they can take action. It says clarify employers' reporting requirements, and then they have this language: use the information to better help Latino, Black, and Asian American communities. I put how I wonder does this do this by having to notify people or report? I guess indirectly.
Probably. Yeah. Find out if there are clusters in industries, perhaps like agriculture, that typically employ the majority Latino employees. Are we having clusters there? Are there clusters in other industries? How do we help this group?
Yeah. Okay, so the requirements apply regardless of where you got the COVID, whether it's contracted in the workplace or not, doesn't matter. It's just a question of whether the COVID appears in the workplace. It's in addition to all Cal OSHA and OSHA requirements so far, and applies to everyone, employers, public and private.
Yep.
Okay, so what does it not apply to? It doesn't apply to employees who work with COVID. The language here is if as part of their duties, they conduct testing or they provide direct patient care or treatment to individuals with COVID, then you don't have to do the notice and reporting.
Right.
Why is that, Lisa?
We noodled over this language. And I think what we came up with is if there is somebody that comes into the facility, you're testing them for COVID, you're treating them for COVID, you do not have to give notice to employees of that exposure because those workers are there and they are exposed every day anyway.
Right.
But you do have to give notice if one of the employees within the facility gets COVID,
right?
As opposed to working with someone from the general public.
Yeah, so we'll see in a minute, but what the standard is for when the employer has to report. And it's basically if anybody comes in there with COVID.
Right.
And so I guess they're saying, look, if you're in an environment where you're dealing with COVID all the time, you're not going to have to every single patient that comes in, for example. Right?
Yes, it would be unduly burdensome.
It would. So but if someone that is a coworker gets it, then you're in the reporting requirements. Okay. All right. Now the notice requirements apply. It says, let's see, slide. Whoop, got ahead of my slide there for a second. Sorry. When the employer receives notice of potential exposure to COVID-19. When the employer receives notice of potential exposure to COVID-19, then the written notices are required to employees. And that's defined in the statute. What does it mean for the employer to receive notice? Because remember, like for the presumption statute, you have to know about a positive test, right? For OSHA, they have to find a work-related injury, things like that. So there's different standards depending on what we're talking about. And when it comes to notifying the other employees, it just depends on whether you got notice of potential exposure to COVID-19. What does that mean? Well, it means that a doctor tells the employer that an employee was exposed to a qualifying individual. We're going to talk about what a qualifying individual is in the next page, but it's basically someone comes into the office and they have COVID. So basically, if a doctor says that an employee was exposed to someone with COVID at the work site, then that would require a notice on the part of the employer. Or if the employee or their emergency contact is a qualified individual, they have COVID, then and the employer becomes aware of it, then they have to give the notice to the other employees. And then there's a couple of other ones which are probably more rare. If the employer becomes aware through the testing protocol of the employer, or the employer becomes aware from a subcontracted employer that there was a qualifying individual on the work side of the employer. Then under these 4 conditions, the notice has to go out. It seems basically like if someone comes into the workplace and an employee is that person, or if a doctor says that someone may have been exposed, and the employer is going to have to provide the notice.
Yeah. Well, what happens if a coworker reports that, gosh, Jim down the hall is coughing up a lung and says he has a fever?
Right.
He might have COVID.
Right.
Is that notice? What if a family member calls who is not their emergency contact and says, my husband, my father has COVID? Is that notice? According to the strict reading of the statute, it doesn't appear to be.
You're right. It doesn't.
But I will say that we expect regulations to come out before implementation January 1st, 2021, that further defines this and gives us more guidance.
We'll be back for another webinar.
Lucky you.
Well, I mean, I think the bottom line is, if when in doubt, send the notice.
Absolutely.
If you as an employer have an idea that there may have been COVID-19 exposure in the workplace, send it. Right? You want to do that to protect yourself from a lawsuit anyway.
Exactly.
Right?
Right.
Now, what's a qualifying individual? This is a key term for the purposes of the statute. A qualifying individual, right? They're the ones that come on and may have COVID and may be infecting the workplace. A qualifying individual is a person who has any one of the following. A lab from case of it, like they got a test and it's positive, both antibodies and diagnostic testing would count, right? So if you have someone who actually have a positive test, then they're a qualifying individual. And another one is a person who has a COVID-19 diagnosis from a doctor. The other 2 are not as common, but they're there. If there's a COVID-19 related order to isolate on a person by a public health official, or someone dies from COVID-19 per the county health department, or per inclusion in the COVID-19 statistics of a county, then this would be a qualifying individual. They're the person that comes onto the workplace and may have COVID, which puts the employer on notice that a qualifying individual may have been exposing their people.
Yep. Right? And a notice has to go out.
It's interesting to me because this is not an employee necessarily. This can be anybody that shows up at the workplace. So I think about school districts and the students, right? If
Absolutely.
The student shows up with a positive COVID test or a diagnosis from a health physician that the employer knows about, they're a qualified individual, and now notice has to be given to the employees.
That's correct. It's going to affect everything.
Could be a vendor, Could be
retail establishments, a
pizza
customer
delivery
comes in,
man.
all of that. Yep.
Yeah, it could be your buddy from
Yep.
high school, South Park. Could be anything, right? I'm not sure how the employer gets notice of all that. I guess it's from the
Contact
employee
tracing,
or
usually.
yeah. Okay.
Yeah.
When a notice is required, it has to be given within 1 business day, and it's a letter. We tried to do our best to give you a letter that you could use. You have to fill in some stuff, and we'll get to that in a second. But within 1 business day, you have to send notice that there's been a positive confirmed case of COVID-19 by a qualified individual, and they provide the written notice. And I put it in bold here, the terms, who has to get the written notice? Who does the employer have to send it to? And there's some terms that I put in bold that need to be defined, and they will be in the next slide. So the language of the statute is that the employer provides written notice to all employees, okay, or employers of subcontracted employees, so the bosses of subcontracted employees on the work site, or just all the employees on the work site, who are on the premises at the same work site as a qualifying individual within the infectious period. All those are terms that we are going to define in the next
Absolutely.
2 slides, because who knows what those things mean.
Yeah.
Also, there needs to be written notice to the exclusive representative of the employees, if any, and we're going to talk about that too. But Lisa told me that means the unions.
That means the unions.
Yeah.
Yep. 99% of the time we're talking about unions, union representation.
Yeah, that's a term of art, exclusive represent. I didn't know it when I was interpreting the statute. So it's funny now. You have to tell the employees, the employers of subcontracted employees, and the union.
Absolutely.
Why?
Yes.
So the union can help you sue in workers' comp?
No. So the union can negotiate with the employees with the employer to ensure that there's a safe and healthy workplace.
Okay.
That's why.
So these are the people that have to be noticed. And what do they mean by these terms? Well, they have this term work site. So the qualifying individual, the person sick with COVID, has to be on the same work site as the employees that get noticed, right? What is a work site, though? That's a good question. They give a couple of definitions here: a building, store, facility, agricultural field, or other location where a worker worked during the infectious period. If you're reading this, you're like, oh, I know what that language is. If you heard me talk about 1159 at all, you know that this is the same language, very close language anyway, that was used to describe the specific workplace, the specific place of work for determining the outbreak presumption statute. So determining if there's an outbreak, you had to notify the people at the specific place of work, and that was defined using almost exactly the same language, which means that the term building is significant, because as opposed to like a complex or a facility, under the outbreak statute is really burdensome. You have to keep track of how many people are working on a given day at a specific place of employment, and we advised that meant keeping track of everyone who's in a given building on a given day, which you can't probably do. Right. But they have the same language here. So if you're determining what a work site is, you're going to use the same thought process. Oh, it's everyone in the building. But then other language was used, which is not used in 1159, and that language is, it does not apply to buildings, floors, or other locations of the employer that a qualified individual did not enter. So I felt that was very clear and easy to understand.
Until there's the caveat.
I'm being sarcastic.
Yeah. So, I mean, how do you interpret that? I used to work for a law firm that had 3 floors, and we were up and down the floors. It had internal stairs. According to this definition, if I didn't go to the 13th floor on a given day and there was an outbreak on the 13th floor, they may not have to notify me. Yeah. I think that reading might be too narrow. And as we've said before, when in doubt, give it to everybody. Because you know what? They're probably going to find out anyway.
Yeah, I think when in doubt, give it to them. Why would you not?
Right. Yeah. Exactly.
It says in a multi-work site environment, the employer need only notify employees who were at the same work site as a qualified individual. But how do you even know?
Well, and that's interesting, because let's say you're a contractor and you have jobs all over the place, and your employees go between jobs in different cities and counties throughout the day, and then end up back at the headquarters at the end of the day. Must we notify every single work site? I think the answer is yes.
Mhm.
I think the answer is yes.
Yeah.
But that also means then you've got to track these people.
Yeah. Just send it to
Yeah.
everybody.
That's what I agree. Send it to everybody.
I would say, look, someone came in our building and we got noticed that someone came into the building on this day who was tested positive for COVID. They sent it to everyone they could think of.
Yep.
I mean, not disclosing qualified, you're just preventing being sued rather than setting yourself up to be sued. You don't have to provide personal information. So
right, you can't.
Why not do it? Yeah. And then there's this term on the premises, which is weird because it says on the premises at the same work site. I can't figure out why that term on the premises is in the statute. It seems like if you're on the work site, you're on the premises.
Right.
But I don't know.
Dare we say poor drafting?
I would never talk that way about our legislature.
Okay.
Yeah,
okay.
Never.
Sorry, I take it back.
They're known. The California legislature is known the world round for its clarity and brevity, and attention to practical detail.
Yeah.
I mean, the thing about principles of statutory construction is that when words are used, they're used for a reason. So that's why I hesitate to ever read a part of a statute and say, well, it's just duplicative of the other words.
Right. And what I expect is we will see regulations, and this happens with employment statutes all the time, that better clarify what was meant by the word used in the statute.
Yeah.
And so I expect to see that here.
Okay. Well, I got some more terminology in the infectious period, because they only have to be notified if they were there during the infectious period. Okay. So how's an employer supposed to know what the infectious period is?
Right. And it's interesting because before this law, guidance to employers was you must tell employees that they were exposed to an employee who tested positive if they were in close contact. And the CDC defines close contact as within 6 feet of an infected employee for 15 minutes. And so those were the people that were getting notices. And these notices at that time were voluntarily given. The California State Department of Health defines that period a little more broadly and defines it as 14 days.
Yeah.
It's a little unclear as to 14 days from what.
Yeah. Well, I mean, what I saw was symptom onset. So I think to be safe, 14 days before and 7 days after.
I think so.
Yeah. Everyone that worked on the work site, on the premises on the work site.
Right. Yeah. And what we're seeing is as the disease progresses and as we get more and more information, we learn about exposure periods and more about infection periods. So we're seeing some revision of what we originally thought in March and April.
Yeah.
So.
Okay. And then there's the exclusive representative that needs to get notified. That's not defined, but you said union rep. Union. I thought, well, maybe it could be a lawyer, maybe it could be a guardian ad litem.
I mean, I suppose it could, but I don't think I've ever seen a lawyer or a guardian ad litem called an exclusive representative, since exclusive representative in my world is a term of art, legal art.
And I wanted to state that when you give a notice to the union, it's not the same as a general notice letter that we gave to everyone else.
Correct.
The language says that you're supposed to provide the same information that would normally be provided in the Cal OSHA form 300, which has got a bunch of information about. So, I mean, it's different. That's a different notice.
It is a different notice, and you have to include the employee's identifying information, their name. And that is not something that you would provide on the written notice to the employee.
Yeah.
So the union gets to know their name, their address, and other information.
Yeah. So there's there's personal information is revealed.
Yep.
Whereas it's not it's not allowed. Very, very important not to reveal it to the employees of the company you're notifying about the exposure. And you don't provide it even under the presumption statutes to the TPA until and unless a claim form is filed. So anyway, it's really tricky about what information you provide to whom when. It's on our chart and we'll go through it today. But first, the method of notice, very, very loosey-goosey. Very, very loosey-goosey.
Well, so I would say from an employment perspective, it's what we expect. So it needs to be done in the manner the employer normally uses to communicate employment-related information.
Yeah.
So you can't just send it by email, because employees who work in the warehouse don't have access to email, right? So you have to be sure that it gets to the employees in the manner you would normally distribute notices. The intranet, for example.
The intranet?
The intranet.
Ooh.
Yeah.
Written notice. Yeah. So it says it's including but not limited to whatever email, text messages, personal service, whatever it has to do to make sure they get it.
Right.
It has to be in English and the language understood by the majority of the employees.
Yeah.
So.
And that's the current standard in employment law anyway, right now.
Is it?
Yep.
Okay. So you know things.
I know things.
Yeah, you know things about employment law. So when you look at the notice content, what's supposed to be in the notice? There's actually 3 different subsections in the statute providing 3 different things, but it doesn't matter because we put it all in one letter for you to use. Okay. But first is just a simple statement that they may have been exposed to COVID-19. That's it.
Yep.
You may have been exposed to COVID-19 on the notice. And then the subsection 3 is the hard one because it just, when I first read it, I was disturbed. I was like, no, it's so many ambiguous terms that there's no possible way I can understand what we're supposed to do. So what we did is we put together a letter. It's a handout, and the things that can be made boilerplate are made boilerplate. And where you need to fill it in, we tell you what to fill in and what you should do to fill it in.
Right. It's basically your own policies and procedures related to leave.
Yes.
And
local
other
laws
benefits.
and other things that can't be determined. But this, and the words in bold here in the language of the statutes are the ones that we're going to throw you for this notice. So it has to be provided to all employees who may have been exposed. And I thought about that for a very long time because that's not the same thing as the conditions under which you have encountered a qualified individual, right?
Correct.
It may not be the same thing as people that were on site and on the premises with the qualifying individual. At the end of the day, though, I got to think it probably is the same thing as people that were on site with the qualified individuals, right?
I think that was the intent.
Yeah, I'm going to go with that.
Yeah.
But it is 2 different legal terms.
It is.
Maybe I get a little too geeky here, but it's 2 different. Yeah.
You are. When in doubt, give it to everybody.
Right. And she's not talking about COVID here, folks.
No, I am not.
All right. So, and the exclusive, you give them to the employees who may have been exposed and the exclusive representative. What's left out here is the people in charge of subcontractors that worked on the work site. So if there is a subcontractor and the subcontractors people work there, then they get notice, right? But they don't get this subsection 3 notice, just subsection 1.
Right.
They just get notice, hey, your people may have been exposed.
Yep.
They don't get the personal notice with all the information about all the rights you get and all the alternatives and benefits and everything. They don't get that because it's just, hey, tell your people they might have been exposed, and it's probably on them, the subcontractor.
Exactly. Yeah. The subcontracted employees aren't entitled to the same benefits that the employees of the company who's providing the notice are entitled to.
Yeah.
They are entitled to the benefits of their employer, which is the subcontracted employer.
Right. Okay. That's good. So they're left off. So you don't have to send a big letter to employers. Because remember, there's 3 people that get notice is the employees that were on the same workplace, right? Same work site. There's the owners of the businesses, if there's subcontractors there, the owners of the subcontractors, and then there's the union rep. So this one only appears to apply to, and remember the union rep gets the Cal OSHA form. So this only goes to the employees that were working on site with the employer. So the other terms here is it says, well, they get notice of, I love this. I just can't believe they said this, but you provide them with information, okay, regarding COVID-19 related benefits. I'm like, oh my God, this is so broad-based. How are we ever going to tailor this to an actual letter? Well, they have further guidance, information, which the employee may be entitled to under applicable federal, state, or local laws. Local laws are hard because local laws are local. So we couldn't really put those in the sample letter. You're gonna have to figure them out.
Right. And some localities have them and some don't.
Right.
So.
And information includes workers' compensation, benefits they may be entitled to under workers' comp. And I thought, wow, that sounds a lot like a claim form and a notice of rights, right? And then options, I love this, Provide information regarding options for exposed employees. Including, I don't know why it cracks me up, but it's just so broad-based. I mean, what is that supposed to mean? Well, it says including, but according to including doesn't mean everything, but related leave, company sick leave. And here's where you put in your company sick leave policies,
Right.
as well as anti-retaliation and anti-discrimination protections of the employee. And that again is company policies,
Absolutely.
right? You didn't
Yep.
put in all of the FEHA law in the sample letter, did you?
No.
No.
No, not at all. Only that law related to COVID-19, which would be the federal Families First Coronavirus Response Act leave.
Yeah.
The Family Medical Leave Act and CFRA are the two federal and state laws, and then your own policies, and then the local laws that supplement these sick leave laws.
Okay. Yeah, it's all in there, folks. Take a look at it. You do have to fill a lot in. You're going to want to get this thing nailed down so you are ready to send it out. It's not that hard. If you have an employment lawyer, you probably want to have them help you out, but it should,
Right.
Our letter should help you out somewhat.
Yeah. And once you have it done, you have it done.
Yeah.
Right.
This slide here, I think, is, I kind of just ran over it in the last slide about the different issues I was seeing going through the language. So, and then finally, remember I said there's three parts of the notice. So the first part applies to everybody. Second part applies just to employees on the work spot. And that's a hard one. That's the letter you have to send out to everybody. And then there's this third one, which is subsection 4, where you have to notify all the employees and the employers of subcontracted employees and the exclusive representatives. This is the union and the employers of the subcontractors and the employees on the disinfection and safety plan that the employer plans to implement and complete per the guidelines of the Federal Centers for Disease Control. What is that?
So when employers opened up after the shelter in place, they were required to have a disinfection and safety plan.
Oh.
That was required to be in place. How are we going to disinfect before we return workers? If there's an outbreak, how are we going to disinfect? Are we going to do it, every day, every hour? What's the plan? So you already should have one of these. And then you also need the safety plan. How are we going to keep our people safe? What kind of PPE are we going to use? What kind of social distancing is appropriate? Can we modify cubicles, workspaces, et cetera? That should be in place. But my advice is take a look at what you have in place. Make sure it's industry specific and tailored specifically to your work site.
Right.
And that should be sufficient. But it doesn't seem that you need to create any additional documents. You just want to be sure that the documents you do have include all the necessary information.
Yeah. Okay. Wow. Yeah, I remember we had to do at the firm. We had to make one of those plans. So you have to attach that to the notice. No, subcontractors are back. So for subcontractors, it's going to be the general notice. What's in the form 300?
Right.
Right. And this, and then the notice that you may have been exposed, your employees may have been exposed.
And the importance of having these documents is it protects you from any lawsuit or complaint from an employee that you've not maintained a safe and healthy work site. And you pull out these policies that you have and you implement. It's one thing to have them, but you have to also implement them and make sure they're being followed. And that's how you protect yourself.
It's a whole world, isn't it?
It's a whole world.
Yeah. And then there's other provisions in this notice, the part of the notice. This is a really interesting line. An employer shall not require employees to disclose medical information unless otherwise required by law. That was a question that came up a lot during the 1159 webinars. Like they say, okay, well, this only applies if there's a positive test. Can we ask them for a positive test? Are they required to give it to us? And the answer is, yeah, you can ask. Are they required to give it to you? No, I don't think so.
Are they required?
It says here, an employer shall not require employees to disclose medical information unless otherwise required by law.
So under FEHA, coronavirus is a direct threat to the workplace.
Okay.
So under FEHA, an employer is allowed to ask those otherwise impermissible medical related questions.
So if you think someone might have COVID, like your employer, the other coworkers say, hey, Bob's sneezing and coughing and maybe he has COVID, then as an employer, you're certainly supposed to investigate, as we'll talk about in a minute under OSHA, right?
But you can ask those questions. Do you have it?
Yeah.
Have you been tested? These are questions you wouldn't be able to ask with relation to any other illness.
What if they refuse to answer?
Then you send them home. You do send them home because the employer is responsible for the health and safety of all its employees.
Okay.
And because it's a direct threat, you have, as an employer, a broader ability to send people home and to ask questions that you wouldn't otherwise have.
Can you require them as a condition of employment to give the positive test?
So that's a debate. We don't know that yet. Can you require one is a vaccine? Can you require them to take the vaccine? I think the answer is no.
Yeah.
Can you require them to test? I think the answer is probably yes, but if you require it, the employer's got to pay for it.
I can see a world when we want to start bringing people back to work, and I would want everyone to get tested before they came back to work. Yeah. And then maybe on a regular basis.
And you have the right to do that, and some workforces do in fact test their employees regularly.
Yeah.
Especially like in the construction industry.
Outsourced to a vendor.
Right, exactly. And a lot of construction companies do have a vendor that they use because they can get the quick tests, and these folks are working in close proximity to each other. Even with masks, they absolutely can't socially distance.
Okay. Well, under the auspices of FEHA, then I guess you can ask these questions.
You can't go beyond that.
Yeah. Well, it says here you can't require them to disclose medical information. You can ask. That's the difference between asking and requiring to disclose medical information.
Right.
Under FEHA, you can ask them, but if you say, I said, what if they don't tell you? And you said you can send them home, but you're still not requiring them to disclose medical information.
Correct. That's correct.
Okay.
Yeah.
All right. So no retaliation is allowed. Not a big surprise here. For disclosing a positive COVID test or diagnosis in order to quarantine or isolate, right? Written records kept for 3 years, and it's enforced by citations and penalties. And then I said to you, what are the citations and penalties? And you said up to 25,000.
A lot.
Well,
and as I'm sitting here, I'm thinking, well, why 3 years? And because I'm a defense attorney and I defend employers against lawsuits, 3 years is a statute of limitations for many types of legal theories.
Okay.
So
there you have it, folks. Statute of limitations.
Yeah, I'm so jaded.
Enforced by citations and penalties.
Yes, it is.
Yeah, I was thinking back to 1159 again on the presumptions and the reporting requirements. The employers, in order to determine if there's an outbreak or not, they have to give information about every positive COVID test, and then in the 45 days preceding, if I remember right, they have to submit information as to the population of each building, location, specific place of employment. And they came up, they said, well, what if we just accepted all the claims in order to avoid this heinous reporting requirement? And the answer was, well, no, the reporting requirements are still there.
Right.
Even though the reason for them is to establish an outbreak, which would lead to a presumption. So you still have to do it. And I never was super clear on the penalties if you don't do that. Do you have any idea?
I do not know.
Yeah, I think it was $10,000 an incident.
Right.
Yeah. So
it's a lot. I mean, if those penalties are enforced, that's a lot of money. In addition to the underlying claim.
So that's notice requirements, folks. Nice and simple.
Yep. Easy peasy.
Easy peasy. And then we got reporting requirements. This is the next section we're going to talk about. This is where you have to tell the local county health organization what's going on. It's totally different than the notification requirements to employers and subcontractors and all that. This is reporting to a public agency. So it says if an employer is notified of the number of cases that meet the definition of a COVID outbreak, and we're going to talk about that in the next slide, within 48 hours, not 24 hours, but 48 hours, they shall notify the local public health agency in the jurisdiction of the worksite, which is, local. We talked about that offline a little. And this notification has all the details about the actual individual, like the name, they name names, right? So names, number, occupation, and the worksite who meet the definition of a qualifying individual. So if an employer knows about it, they got to, 48 hours, they got to tell the local county about it. And they have to provide all the information about the person. There's also a continuous reporting requirement. So if you give notice once, if you're required to do this once, you got to keep doing it. So if you find out that you meet the definition of outbreak and you tell the local county, then you got to keep tabs on it. And then it says the employer shall continue to give notice of any subsequent laboratory confirmed cases of COVID-19 at the worksite. Note that the continuing reporting requirement is only to do with positive confirmed laboratory tests, right? Whereas the original duty to report is just if you're notified of an outbreak.
Right.
Right. So I don't know. It doesn't say how long that duty goes on.
Yeah. And at the risk of guessing, I would say it's during the period of the outbreak.
Yeah. I don't know. I mean, what is the period of an outbreak?
Yeah. I don't know.
Or maybe it's all the way till 2023 when the statute sunsets.
Right.
I don't know.
So if your workplace is part of an outbreak, then you have a continuing obligation forevermore to report positive cases to the public health authority.
No, I mean, the sunsets on 1/23.
Well, I know. So, but for every positive case, does this say you have to report it to the public health agency, whether or not it's part of an outbreak or not?
No. Oh, yeah, you're right. Because it's like, well, it just says that if you do give notice of an outbreak,
right,
then you have this obligation to report any positive test.
Till 2023.
Well, I would guess. I don't know.
Yeah.
Doesn't say.
The regs will let us know.
God bless the regs.
I was going to say, thank goodness for the regulations.
If they appear. So anyway, here's some issues I identify. What's an outbreak? It's important to compare it to 1159 because outbreak in 1159, the presumption statute, is where you have a specific place of employment with 4% of the people test positive for COVID. Or if it's less than 100 people, it's 4 people. Okay, that's an outbreak. Right. This is a different definition of outbreak, not the same thing. An outbreak defined by the Department of Public Health is 3 or more laboratory confirmed cases, positive tests, within a 2-week period among workers who live in a different household.
Yep.
Far out.
Yep.
I mean, there's a whole lot of geekiness I could do on that language.
I know. And my comment is it would be much more efficient if all of these laws would have the same definitions. Because employers have a lot, there's a burden on employers to just deal with record keeping related to COVID.
I know. They just can't do it, though.
It's crazy.
They can't do it. They cannot do it. Anyway, so that's an outbreak here. That's how that's defined. I noted in the prior slide that it's really interesting to me that all this personal information is required. I'm not sure why they want all the personal information of the person with the but they can't disclose it to the public.
Now, the only reason I can think of is to help with contact tracing.
Yeah.
Right. So they know the name of the person who's infected. They can talk to that person, find out who they've been in contact with, and then they can go out and do their contact tracing, which I do know that the Department of Public Health does do contact tracing for outbreaks.
Okay. Yeah.
So.
Well, anyway, and then the last thing it says is that this reporting an outbreak is not required for a health facility. Under Health and Safety Code Section 1250. We explored that in the last webinar. 1250 is basically hospitals.
Yep.
If you're going to stay overnight, take care of someone, you don't have to report that outbreak for the health facility, I guess, because I don't know why. I mean,
it might be expected there.
I guess. No, I don't know why.
That's why you go to the hospital?
I would think that the Department of Public Health would want to know about that too.
Yeah, well.
But you don't have to for that.
Yep.
I mean, you probably will end up doing it. Okay.
Cal OSHA.
Now this is where you're going to lead us.
Yes.
I don't know anything about this.
Yeah. So Cal OSHA is California State's version of the federal OSHA statute, and there are separate reporting and recording requirements for employers under these provisions. And this law does not change what most employers already had to do. Fill out the record events on the 300 log and report certain injuries and illnesses. What this does, though, is apply it specifically to COVID-19. Okay. What are we going to do there? So Cal OSHA may now come in and shut down workplaces that are an imminent hazard. And this is interesting because they've always had the power to shut down workplaces, but they have in the past given the employer 15 days notice
Hmm.
so that the employer could then do its own investigation and rebut any of Cal OSHA's findings.
Try to
Now,
keep their doors open.
exactly.
Okay.
Now Cal OSHA can come right in, shut you down, no questions asked.
Wow.
If there's an imminent hazard. Well, what is an imminent hazard?
Well, that's a good question.
You know, it's a threat of death or serious physical harm. Okay, well, how are we going to apply that to COVID? Because
anybody with COVID.
Yeah, potentially could die.
It's a threat.
Yeah, or they could have a significant illness as a result. But the health hazard must be a reasonable expectation, and that the exposure to COVID-19 will shorten life or cause significant reduction in physical or mental efficiency. Clear as mud. So the way I think this is probably going to be implemented is in cases of outbreaks, or in cases where you have a single case of COVID, but Cal OSHA finds the employer doesn't have the requisite policies and procedures in place that they're required to have. They could come in and shut down either the entire workplace or portions of the workplace, departments, operations, etc. And so it's going to be somewhat fact specific.
Well, would it only be where there's an outbreak? I mean, because just a single person having COVID at a work location could meet that definition of a threat, I would think.
Yes, I think you're right. And I think in those situations, they may want to shut you down or at least shut down the operation in which that employee worked if the employer, A, doesn't have the proper policies and procedures they're supposed to have, or B, is not implementing them.
Yeah, wow, that's crazy.
Yeah.
Imagine them at Tesla when someone on the factory floor gets COVID.
Right.
They come and shut them down.
Exactly.
Oh my God.
But practically speaking, they probably won't. They're going to need more than that. Okay.
All right. Tell us some more about OSHA though. I mean, I wanted to do this one. This is, I wanted to just jump in at the end and say this is on our sheet that we're distributing. This is what employers have to face. If you have your own company, you have to notify your employers. You have to report to the public health agency, like we just said. You have to report under the presumption statute to claims administrators for positive COVID tests. And then you have to report under general Cal OSHA laws. And so all four of these things have to be done by the employer. They all have different standards for when the reporting or notification is required, how much time you have, the method by doing it, and what it's supposed to contain and how it's transmitted, the whole thing. So we have the sheet and you should print out and look at it. But I wanted to walk through a couple of points along these lines. Here's like, for example, so the outright presumption, you report to the claims administrator. The employee notification goes to employees, and we talked about. The sheet itself is a lot bigger than this with a lot more information, but the other things too. And then the local public agency has to report it, or OSHA. And these are the different requisite knowledge: a positive COVID test, a potential exposure to COVID, right? An outbreak. It just depends on what kind of reporting we're talking about. So you can figure out what you got in these categories, and then you'll figure out who you report to.
Right.
Yeah.
And the notice that you'll see is more detailed, longer, but it will be very helpful in figuring out who you have to report to when and what the notice has to contain.
3 business days, 1 business days, 48 hours, 5 days.
Yeah.
And how. So like I said, our sheets are much more complete on this, but this should help employers figure out what they got and what they got to do.
Yep.
That's our goal. We did want to compare the OSHA obligations to record and to report, just to because this is part of what the employers have to do.
Yeah, and employers are required to record in any event, but this is an obligation specific to COVID-19. It has to be a confirmed case.
Okay.
Generally, at least one positive test. It has to be work related. And that's interesting. How are we going to determine whether or not COVID's work related or not? It has to involve one or more of the general recording criteria, meaning there must be more than first aid or days away from work.
Okay.
So
there's some other things on that list too, if I recall.
Death, restricted work, or transfer. In other words,
this is where you just write it down and keep it. You don't have to tell anybody.
Medical treatment. Loss of consciousness, that would qualify. And determining work relatedness, you have to consider the type, extent, duration of contact the employee had with coworkers, right? If we have everybody in separate offices, that is a different exposure level than if we have everybody working in a communal room.
Right.
Right. So that's one of the things that you would look at. Is there a cluster? Is there an outbreak? If there's an outbreak, it's probably more likely work related than not, than simply community exposure. So there is an obligation to do an investigation to determine whether or not it's work related.
I see. And what about, when do you have to report it? When does OSHA require reporting?
Bad stuff has to happen.
Bad stuff.
Yes, bad stuff has to happen.
Okay.
You must report any serious illness, serious injury, or death. And it's interesting because the definitions are
serious illness, huh?
Yeah, are not great. Serious illness is defined as illness contracted in, quote, connection with work, unquote. Symptoms may arise outside work, but may still be reportable. What does that tell us? Virtually nothing, right?
I mean, to anyone, the person with the illness, it's always serious.
Oh,
COVID
absolutely.
is a serious illness by definition.
Absolutely.
So I would say you have to report everything.
Well, and it's different though. It's different because what if you're asymptomatic?
Oh,
that's different than somebody who's one of the long haulers.
Is it? I mean, isn't that still serious illness? No.
So
it doesn't
no,
seem like it.
No, because for Cal OSHA, reporting requirements are supposed to only be those illnesses and injuries that are significant. As a matter of fact, many employers never have to report anything ever because none of their injuries or illnesses, usually it's injuries, are that serious. So,
okay.
All
right.
So it's vague. It's not entirely clear, but I do expect that we will see regs that further define the obligation to report.
Okay.
So, for example, inpatient hospitalizations, that would require an employer to report.
Okay.
Well, what does inpatient hospitalization mean? For reasons other than medical observation or diagnostic testing. How quickly do you have to report inpatient hospitalizations? Well, if the work-related incident or exposure occurred within 24 hours. So is the hospitalization within 24 hours of the work-related illness? Probably not, right? With COVID, how do we figure that out?
I don't know.
So it's difficult, and really the commentary is we may not ever have a COVID-19 case that falls within a reporting requirement.
Well, what if he dies?
Well, if he dies, yes.
Okay.
Yeah. If he dies, yes.
All right.
And it's work related. And yes.
Well, that's the last slide we had, which is, sorry. I think we went over that already. The last slide I wanted to talk about was the duty to provide a claim form, because I looked at this and originally I saw that where there's one qualifying employee, then you have to provide all employees notice of their workers' comp rights. And I thought, I wonder if that's means that every time there's a COVID case, you have to give a claim form and notice of rights. But then I realized this isn't going to the person that's sick. This is going to everyone else, right?
Right.
So it doesn't require notice, or it doesn't have any impact, I don't think, on the duty to provide a claim form.
Right.
The duty to provide a claim form is a tough area. We've talked about it in multiple webinars. It doesn't really, the Honeywell case is really clear. It's only when there's actual knowledge, not reasonable certainty, that you have to provide a claim form to employees. But, after we announced that and thought about it and realized that you didn't have to give a claim form out a lot of the time when someone had COVID, up came OSHA in May with this new requirement that you have to investigate it when someone might have COVID. And what does that even mean? Well, we talked about it, but I mean, you have to really look into it and ask the questions. Ask where'd you get it? Look at who has it at work, who has it at home. Ask the questions, get the medicals if you can, and make a determination as to whether it was work related or not for purposes of reporting to OSHA. So that investigation has to be done. Now, if you do the investigation and find out that you think it's probably work related, does that mean that you have to provide a claim form? I'm arguing with my co-author, sure, about this quite a lot. I don't think so, because not in all cases anyway, because you could go and investigate it, and by a more likely than not standard, decide this probably happened at work and then report it. But that doesn't mean for purposes of the workers' comp standard. But we're getting pretty close here.
Yeah.
So I think
You're
a lot of,
splitting hairs,
yeah,
it sounds like.
well, no, I don't,
Uh,
that's what sure thinks.
Yeah. Uh-huh.
But not me. But more and more employers are just providing them.
Yep.
Yeah, when in doubt, even if they risk taking on claims that might not other exist. But
Yeah.
I see by the clock that you and I have talked our way through an hour.
Wow.
And we have to stop talking about.
Bummer.
Here's the good news though. We can go offline and keep talking about workers'
notice
comp.
and reporting requirements. Yes.
And we
Yes.
can go home and tell our families.
Uh-huh.
They're always really interested in a really granular level of workers' comp detail, in my
Oh,
experience.
yes, I know. I know. Well, at least employment law is a little more interesting.
Thrilling isn't too strong a word for what we provided here today. It is boring stuff, but put out
Necessary stuff.
necessary stuff. If you're an employer, print out your sheet, look at it, get your notices ready, and get ready to comply with the law. And that way, they don't put you out of business with legal fines. So
Absolutely.
all right, folks. Well, it's a pleasure to check in with all of you again. Here's our contact information for Sullivan and Comp. We hope it was helpful. As always, we'll be getting a whole bunch of questions by email and other sources, and we'll be happy to answer them. And we're ready to consult both in the employment law and workers' comp divisions of our firm on any questions you may have.
Right.
And leaving it at that, I'll sign off and say thank you, Lisa. On behalf of her and myself, it's a pleasure speaking with you all today.